Morning, everybody.
Morning, Your Honor.
Good morning. Back before the court is Hampton County Civil Action 1780 CV 0033, Patrick Buchanan et al. Versus the City of Greenfield et al. The matter that's currently on trial.
Okay, we're still waiting for 3 jurors, I believe. I have received and reviewed the plaintiff's joint motion to correct answer to jury question that was from yesterday. Have defendants' counsel had an opportunity to review the motion yet?
Briefly.
Would you like some more time to do so?
I don't think so.
Okay. Okay. I understand and respect the heft of your motion. As with everything else that has happened in this case, the reason why this case has been tried in such a erratic manner largely due to the fact that these are issues that really should have come up a week and a half ago. But having said all that, I understand your point, okay? So I'm going to ask you to refrain from repetitive and argumentative comments. Okay?
Yes, Your Honor.
So, if you wish to be heard further, I'll hear from you. Otherwise, I'm going to turn to Attorney Keston. And I do want to frame some of the issues because there are some truths, legal truths, that need to be more clearly spelled out for this poor jury. Okay? First, both sides of this conflict have reflected that the municipality or employer is liable for the actions of its supervisors. I disagree that Collegetown uses the term strictly liable. I know that's what the was requested, but it's not a matter of quote unquote strict liability, which imputes all sorts of legal importance. There's liability though. So the first, I believe, legal truth that I'd like to simply get a simple answer from counsel and a candid answer is that, in large part because this has been argued in defendants' motions on different occasions, there is an acknowledgement that an employer is liable for the actions of its supervisors. Is that, I take it no one is contesting that on the defense side.
That's correct, Your Honor. We are not contesting.
Okay. The second, it appears to me to be truth, relates to who the supervisors were in 2020 and 2021. And I believe that both sides acknowledge that there were 2. There was Chief Haig and Mayor Wiedegartner. I take it that's, and I respect that the plaintiffs are still trying to get in Sergeant McCarthy or others, but as to that particular, it appears to me to be a factual truth. Do the plaintiffs acknowledge that?
Yes, sir.
Okay. Attorney Keston.
Yes, sir.
Okay, thank you. So, the reason why I separated them out was to create clarity, okay, as to whether or not there was liability inuring to Chief Haig. I respect and understand the plaintiff's argument that even though there is a separate question that Chief Haig still inure, so to speak, to the city based upon the legal principle and factual issues that I just identified, okay? So, but having said that, the jury would still be required to respond to the separate question. So in order to frame the issue, let me tell you what I am considering, Attorney Keston, okay? And then I'll hear from you, and then I'll turn back to the plaintiffs, okay? Oh, it's jam time. Okay, that's quite all right. In response to your question marked as K for ID, I further respond as follows. Yes, Chief Haig, because the question was only related to Chief Haig. When answering question 6, are we to include Chief Haig as a part of the city of Greenfield? That's the question. I further respond as follows. Yes, Chief Haig is included as part of the, quote, city of Greenfield as set forth in question 6. In deciding question 6, You are to consider the actions of Chief Haig and Mayor Wiedegartner. That is because the city of Greenfield is liable for the actions of Chief Haig and Mayor Wiedegartner. I can put in, if any. Notwithstanding my reply, you're required to answer question 7. Okay, so would you like me to repeat that?
Thank you.
Happy to. I can print this out if you like.
No, I just,
Yes, that would be great, Your Honor. Thank
Let
you.
me do that. Okay,
let's try.
hold on. I am adding in, if any, just to be balanced. Okay. While I'm doing this, I'm attempting to reschedule something that I may not be able to reschedule for tomorrow afternoon, because I don't think anyone anticipated being here at this point. But I may be telling this jury that if they're still deliberating tomorrow at noon, I'll see them on Monday. So,
Sorry.
yeah, I didn't hear what you said, so
No, I just whined. I started crying.
that's
It
okay.
wasn't anything.
That's quite all right. Yeah, if you don't mind grabbing that. While she's doing that, settlement discussions occur all the time at this level, okay? Particularly with the jury, which, as this jury, has been out for 3.5, 4 days, okay? Clearly, they are going through the evidence, okay? I'll leave it at that. Great. Let me take a. Okay, so let me just take a look at it first. Okay, we'll share that with you.
Thank you.
And a couple of things that are off the table. The word "strictly" is it's just not a correct recitation of the law. Any such supervisor, the employee of the city, it's limited to those two at this point. So I'm not broadening it. So.
That's fine. That's no objection.
No objection.
Okay. Attorney Kessman.
I don't see why we need question 7.
I'm sorry?
I don't see why we need question 7.
The only reason why question 7 was put in there in the first instance, I'm not disagreeing with you, okay, was to make clear whether or not there was liability for a different supervisor. But at the end of the day, when I think about this medusa of an issue that you all are going to have, to the extent that there's a plaintiff verdict on damages, okay? At the end of the day, in a practical sense, I don't know if this is true, but I would think that were there, for example, a judgment against Chief Haig, okay, as well as the city, that the city would indemnify and cover Chief Haig, okay? You don't need to tell me yes or no to that. But like in a med mal action, counsel generally stipulate that any judgment against a nurse or a doctor, is going to, in order to, whatever the organizational entity might be, okay? That's not a nonprofit or whatever have you, or a nurse would in order to a doctor, okay? So that's one way for me to get a little more sleep at night on this issue of damages in this case, that if there are plaintiff's verdicts, or at least a verdict relative to Mr. Buchanan, it seems to me that might be a truth. I don't know whether or not it's a truth because I don't know what the relationship is between the parties and the insurers and that sort of thing, okay? But when I separated out the questions, it was with a concern in that regard in mind. If with this question There now is an acknowledgement that the actions of Chief Hague and Mayor Wiedegartner, this is only in relation to 2020-21, by the way, are joint and several, so to speak. Okay, then maybe it's not necessary to have. But question 7. Having said that, let me take another look at question 7 because I don't know that it just relates to 2020. I think it does. Can I see? Do you have a copy of the special? Pardon me? Yeah. Thank you. Yeah. So this is what I'm going to do. I'm going to step on the bench and let you all discuss that particular issue. Okay. I'm open-minded in that regard. I do want to, since they're deliberating, I don't know if there's a huge rush about it, but I'm kind of hopeful today will be the day. And certainly that goes no further than here. They'll take as long as they need. But I do want to get this to them sooner than later. Take a brief moment, if you would, and discuss, see if there is an agreement relative to either the language here and or whether or not we leave in question 7. If I leave in question 7, then I've addressed it by simply saying, notwithstanding question 6, you still need to answer question 7. Which may create a clearer vision as to who they were thinking. So that, for example, they answered no to question 7, but yes to question 6. We're talking about Mayor Wiedegartner, which is something you may want. Okay? Meaning you may want to know what they were thinking, okay, for post-judgment purposes. So
it's actually, well, yes, maybe for the J&OB purpose.
And that's part of my thinking in terms of where we're trying to create some judgment that is going to create some degree of clarity for post-judgment purposes and appellate purposes. Okay, that's one of the reasons why we're doing what we are doing. So, in understanding that, do you withdraw your request to remove question 7?
No.
You still want to withdraw it?
Yeah, I'm already quite confident in the
Okay, that's fine. So
process.
Okay, I'm going to give you a moment then to talk about the question itself, and then I'll come back and let you know whether or not I'm going to leave question 7 in or not. And I respect that last sentence, notwithstanding my reply, has everything to do with that question. So I will take one moment. I don't think it'll take long for you all to say no to each other. So
We're back in session. Please be seated.
let's see, could have this. Our jurors are back, and I do want to get them started, and I don't want to bring them in, send them out, and bring them back in. And I understand, Attorney Brody, you were typing something, which I respect. You can read it to me, though, because if we had good Wi-Fi, I would get it immediately.
Okay.
But it'll take me half an hour to get it.
All right.
And they're still objecting. They want 7 in. Yes, Your Honor.
Yeah, I understand that. I understand that.
And they also don't want this instruction.
Right. So let me
I'm going to
take.
give you my handwritten version, and I'll read to you what I am proposing.
Is this what you are proposing?
Yeah, can you read it?
Yeah.
Oh, great.
Okay. All right. I'll read it into the record. In response to your question marked as K for idea, further respond as follows. Yes, Chief Hague is included as part of the City of Greenfield as set forth in question 6. In deciding question 6, you are only to consider the actions of Chief Hague and Mayor Wiedegartner. Okay? That is because the City of Greenfield is only, liable for the actions of its supervisors. Okay, that's a bit of a bow to the plaintiff's request.
I think I agree with that, Judge. I was frantically trying to write something.
Well,
I think that we could.
I'm formatting some ideas.
Okay.
You must answer question 7.
And there was another sentence.
I got it. I'm getting
Okay.
to it. I instruct you, the only supervisors you may consider in response to this question are Chief Hague and Mayor Weidergarten, or both. Oh, so I see what you're doing. You're kind of saying it all. One moment, please.
Oh, what do you want to say about this one?
Okay. Have you seen this handwritten version?
Yes, sir.
Okay. So, let me make a couple of observations. I think the word "only" is fine. Okay, it's what I intended. Okay, you're a city of Greenfield's liable for the actions of its supervisors. You all agree upon that.
Yes, sir.
Okay, and then further, the only supervisors are Chief Hague and Mayor Weidergarten, or both. Okay. And then you must answer question 7, which I'm going to leave 7 in. Okay. I'm fine with this. Okay. What, if any, is the objection?
We just think that your version was perfect the first time we wrote it, Your Honor. And then the second only, I don't know.
It's a second only, Your Honor.
I'm sorry?
The second time the word only is introduced.
Oh, I see. You are, the second question, you are to, this is, okay. I'll take out 1. The city of Greenfield is liable for the actions of its supervisors.
Thank you, Your Honor.
Okay. Very good. Thank you for working collaboratively on that. I'm going to print this off, and thank you, Attorney Brody, for being helpful as you have been throughout this trial. You really should let her handle some of, the evidence too. I'm sure she'd do a great job.
Your Honor, on the retrial, she'll do it.
Yeah.
Because we'll be back.
Exactly. Yeah. Yes.
I'd like
Yeah.
to start next week.
Yeah. Well, no, actually, were there any, as promised, it will be, I don't know, October, November 2023.
Oh, come on. Wouldn't you like to just keep going?
No. Although I'll make sure I'll be here. Were there any round 2?
We'll be around.
For that. Okay, I think this is printing off right now. If you don't mind grabbing that, if you can return this to Attorney Brody.
Thank you.
Although you have nearly all driven me into an early retirement, I promise to stay. Let me take a quick look at it. For the response as follows. Yes, Chief Hague is included as part of the city. Greenfield set forth in question 6 and decided questions. You only consider the actions that are mayor. Okay, that is because the city is liable for the actions of its supervisor and district. The only supervisor you may consider. Oh, I need to add in a comma. Okay, so I'm going to just reprint this right now. And it's good to go. Okay, let's bring in the jury.
Your shoe's untied.
Should be the least of his concerns.
It's going to be a great chapter in my book.
Yes, please. So,
Thank you.
this will be, thank you, 04 ID.
You're in charge, right? Yeah, I'm not looking at it. He said, because of all this stuff, I'm letting you know.
Jerry Hendrick. Hampshire County Superior Court is back in session. We can see it.
Good morning, members of the jury, and thank you for your patience. I will simply say to you that counsel and I have been hard at work since 8:30 this morning, and so I do apologize for the slight delay in our getting started. I'll first start off by inquiring, has anything come to your attention since I have last seen you in court, which has affected your ability to remain fair, to remain impartial? Hearing no affirmative responses. Ladies and gentlemen, I'm going to give you what has been marked as O for ID, okay? I'll read it into the record. In response to your question marked as K for ID, and I'll simply tell you that that question was when answering question 6, are we to include Chief Hague as a part of the city of Greenfield? That was that question. I further respond as follows. Yes, Chief Hague is included as part of the city of Greenfield, in quotes, as set forth in question 6. In deciding question 6, you were to only consider the actions of Chief Hague and Mayor Wiedegartner. That is because the city of Greenfield is liable for the actions of its supervisors. I instruct you the only supervisors you may consider in response to this question are Chief Hague, Mayor Wiedegartner, or both. Notwithstanding my reply, you must answer question 7, okay? So that you must answer question 6, and then you must also answer question 7, okay? Well, ladies and gentlemen, let me say that my job is to ensure that this case has been tried in a manner which is fair and orderly and efficient. I'm not going to pretend that much of what has occurred over the past 2 days or so approaches orderly or perhaps efficient. And for that, I take full responsibility, and I apologize to you. But I do believe that it has been fair. So having said all that, you may now return. Good afternoon, everybody.
Good afternoon, Your Honor. It's a beautiful day in Northampton.
Yes, it is. All right.
Hampshire County Superior Court is now in session. Please.
Your Honor, we're back on the civil action 1780-033.
All right, we have a question from the jury. Are we allowed to know the date of this lawsuit being filed? Second question. When was Todd Dodge added to the lawsuit? Okay. So I have my thoughts as to what the answers to these two questions should be. I'm happy to start off with Attorney Ryan.
Your Honor, we don't see how you can answer it in the positive. I'm sure you can frame it negatively so that...
As in no?
As in no, and here's why, but I don't see how we add additional information at this point.
Okay, I appreciate that. Thank you very much. I take it you agree with that.
My instant reaction was no.
Yeah.
That's
Okay.
the answer.
That's well, I'm glad to see that you all agree and you correctly agree. Okay.
And you agree too?
Yeah, of course I do.
This is fabulous.
Okay.
Let it be written, so let it be done.
Yes. Okay, one moment, please, then.
For the record, Your Honor, this is P for identification.
Thank you.
P is in Peter.
Okay, I'm going to write out a written response to trial, read to you, which marked as Q for ID.
Q, I'm sorry, Q for ID.
Well, the note is P, but my response will be Q. Okay.
All right.
Since there are two questions, I'm going to write them out and answer them separately. I'm going to give them a little more fulsome answer so that they understand rather than just no, which will be, we're allowed to know the date of the date of this lawsuit being filed. You are to base your deliberations upon the evidence that has come before you. I can provide you with no further information responsive to your question. Okay? Any objection to that?
No, Your Honor.
No, Your Honor.
Your Honor.
Okay.
Although no would be more succinct.
Well, they just may not fully understand. I mean, because the question is, are we allowed to know? Well, if somehow it came into evidence somehow, not that I believe it did, I don't want to refute whatever their understanding is. So
I'm being
Yourself.
yourself, yes. I was going to say facetious, but that would be polite.
I
Okay.
have responded to long-winded demand letters with no.
You are.
Dear so-and-so, no. I think I said I demand a written response. Okay. You get one. Cold and rainy day, 2019.
2019?
Whatever it was that Tim followed off.
Which one?
The lawsuit. There's only one lawsuit.
No, what I meant.
Oh, that's right.
The initial lawsuit was filed in 2017.
That's right.
Captions.
Answer. You are to base your deliberations upon the facts adduced at trial and the law as I have instructed. I cannot provide you with further information responsive to your question. Then I repeated the next question: when was Todd Dodge added to the lawsuit? And my answer is the same as my answer above. Any objection?
No objection, Your Honor.
No, Your Honor.
No objection.
Okay, great. That'll be marked then as Q for ID. And we'll let them continue. Okay.
On the record on 1780 CV 0033, the matter on for trial.
Okay. We have another question from the jury. Let's mark this for identification, please.
That'll be R for ID, Your Honor.
Okay, so that would be R for ID. You both have been given copies of the question, which I will read into the record. If we are to award lost back wages, are we to consider pension as a part of it? If so, is there a specific formula? At the same time, the jurors requested if they could have calculators, principally because we take their cell phones, so they have no ability to calculate anything. So that's, I presume, why they asked for calculators, because otherwise they're left to simple arithmetic. As I understand, counsel all agreed that they could get calculators. Is that correct, Attorney Ryan?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, and so that's what was reported to me. They were given calculators. I requested that counsel provide a written response. I really appreciate your having taken the time to do so. I'm going to read them into the record. Plaintiffs, this is a joint proposed response. It says, similar to the last response, you must make your decision based upon the evidence before you. The defendant's response, you are not to consider pension benefits, only lost wages. I think that the defendant's response comes more neatly, is more neatly aligned with what the response should be. I do want to at least raise an issue while I'm inclined to allow the defendant's request. This question can mean a number of different things. First of all, there are claims for lost wages on behalf of both plaintiffs. Obviously, there's no claim for pension on behalf of Lieutenant Dodge. So I will presume that this relates to Mr. Buchanan, although it doesn't specify that. But one of the questions that arises that you may wish to contemplate is the chalk which they have with them. And I don't have it in front of me. I don't know whether or not there is an indication on that chalk, whereas it's many pages, that indicates pension payments that Mr. Buchanan has received since he's retired. Nor do I recall any testimony necessarily as to his receipt of retirement pension. Maybe he's not getting because he's not old enough yet. So, Attorney Ryan, can you shed some light on that?
Your Honor, my memory of the chalk is it's just the differential in wages up until the date of retirement, and it stops there with the net figure of approximately $88,500.
Okay, all right, because there was no testimony that I recall as to his current receipt of pension benefits. Am I correct in that regard?
Your memory is consistent with my own.
Okay, all right. So that facilitates the answer to this question, which I believe is Attorney Keston's answer, which is you are not to consider pension benefits, only lost wages. Okay, so I'll hear from you in that regard. Let me start with Attorney McDonough, since you're rising to the bar, as we say.
I would just end with you're not to consider pension if that's where your prerogative is. There are.
Oh yeah, absolutely. There are claims for emotional distress. I do apologize. Actually, I was going down that direction myself. You're not, or rather, what I was formulating in my mind was.
Go ahead.
Just, I'll be with 1 moment, please. Okay. Well, to track their language, if you were to award lost back wages, you are not to consider pension benefits, period.
Period.
Okay. Attorney Keston?
Yes, sir.
Okay. Attorney Ryan?
No objection, Your Honor.
Attorney McDonough?
No objection.
Okay, bear with me a moment. Let me write that up. So that was R, right?
Oh, that was our, Your Honor.
Okay, so this will be S for ID. Reads as follows. In response to your question, Mark, R for ID, I respond as follows. If you were to award lost back wages, you are not to consider pension benefits. Okay?
No objection, Your Honor.
Thank you, Your Honor.
No objection, sir.
Okay, I'm going to say one thing. I started off the day by saying that lots of cases settle even while juries are out to deliberate. Okay? I cannot forecast what this jury is going to do. Okay? This is a jury which has posed a question relative to damages. They've asked for calculators. This is a case in which we now have 85% interest running, and through any appellate process, will double. And if the jury's verdict is upheld, it will be a significant loss to defendants. There is good reason, more reason now than even when I spoke with you this morning, for the parties to consider the direction that this case might go, cutting your losses short, that is to say, foregoing the risk which is entailed in not just appellate review, but post-judgment review. For I have the authority to limit damages, and I think Attorney McDonough knows that I'm not afraid to do that. Okay? And I'm referring to a case in which I lopped off, about $10 million
$12 million.
to be exact. Okay?
That's a big lot.
So, I speak to the plaintiffs. I'm sorry that Chief Haig is here, but I'm sorry that the mayor's not here. Think about it. Think about where you wish to go today, where you wish to be 2 years from now, because this jury's verdict will not be the end of this case at all. Okay? So, having said all that,
Next Superior Court is now in session. Please be seated.
We're back on the matter on for trial, 1780 CV 0033.
Right, ladies and gentlemen, we're going to suspend until 9 o'clock tomorrow. I do wish you to consider the following. I am contemplating going to 12:15 tomorrow, but that is not necessary. My question that I'm going to ask you to report to one of the court officers by tomorrow morning is, if you have not concluded your deliberations by 12:15 tomorrow, either A, are you able to return on Monday for your deliberations, or B, do you just truly prefer to continue throughout the day? I only pose that question because I have other matters that are scheduled. I'm happy to reschedule them if necessary. But I do wish you to consider that question. You can report it to the court officer tomorrow, and we shall take it from there with the ongoing instruction not to discuss the case with anyone, including amongst yourselves, nor to do any investigation or research or look at any media reports. Enjoy what is left of this beautiful day. I'll look forward to seeing you tomorrow morning at 9 o'clock. Thank you.
Refresh.